like people say, well, what business do you have coming in here talking about science and all that? You're an actor. You want to know what my first patent was? The entire AR VR world was built off of my first patent that was abandoned because I paid $260,000 for the worldwide patent. But then my agents kept, my lawyers kept sending me these maintenance fees and annuities. And I'm like, these folks are just trying to shake me down. I'm not going to pay it.
Hold on. Did he just say he paid $250,000 for a patent? Hey, if you guys don't know, welcome to Everything Intellectual Property. I react to this Terrance Howard interview that has been going viral on the Joe Rogan podcast. He was on there recently. And hey, man, as an intellectual property attorney who's been doing this for almost 10 years, dealing with everything from patents to trademarks to trade secrets, NIL, it's a few things I've heard that was the issue with this first statement. Number one, again, yes, for all of us who know, patents can get expensive. But if you're telling me, and again, I've seen the expensive side of things. If you're telling me you spent $250,000 on one patent, well, again, I don't know. I guess he said that he patented the whole VR AR universe, which is another issue. If you talk about you patent all of this stuff, that's a red flag to me. But if you're saying that you spent $250,000 on one patent, I'm going to say that you got screwed. Now, I'm not going to say he got screwed on this one. I'm going to just say he's embellishing a little bit. But let's get back to it and see what he's saying. And then my thoughts again.
Yes. Well, a year later, if you pull up my World of Windows patent, I think it's one of the first patents up there. I want you to see where your AR VR world came from and look at the list of companies that has cited and didn't just cite it. They built their entire AR VR world off of my World of Windows patent. Can you pull that up, Jamie? Of the computer. Yeah, it's the very, not that one. Yeah, that's the propulsion patent. No. That's all you have, huh? Really?
Gotta get the.
If you can go to
the receipt.
Terry's linchpin, I'll show you on here. This is what this is.
He came with receipts.
Is that online? This is online.
Text me that link and I'll just send it.
Yeah.
You got it?
You got it.
Okay.
So merging virtual reality. It says merging virtual reality with reality. Go down. Patents and files. The very first one. Tap on that. So you go look over to, you'll see my name, inventor, Terrance Howard. Worldwide application. Let's just read the abstract just so they.
System and method for merging virtual reality and reality. Scroll up to provide an enhanced sensory experience. A system and method of merging virtual reality sensory detail from a remote site into a room environment at a local site. The system preferably includes at least one image server, a plurality of image collection devices, a display system comprising display devices, a control unit, digital processor, and a viewer position detector. The control unit preferably receives the viewer position information and transmits instructions to the digital processor. The digital processor preferably processes source data representing an aggregated field of view from the image capturing devices in accordance with the instructions received from the control unit and outputs the refined data representing a desired display view to be displayed on one or more display devices wherein the viewer position detector dynamically determines the position of the viewer in the room environment and changes the desired display view corresponding to position changes of the viewer.
Now you see
this is all you.
Yeah, look at the inventor. Go up a little bit. Slide over. It says Terrance Howard.
Yeah.
Worldwide patent 2010. It was abandoned. Now go to cited by. You see that 131?
Hold on. Look at man. So you can't really see this. So I'm gonna pull it up on my screen. Hey, because when you talking about patents, that's my game right there. And if anything, Terrance Howard needs to give his attorney some kudos, because that's what I hear this all the time. Let me put the screen on back on me for a second before we look through the patent. I hear this all the time when I draft a patent application from an inventor. They're like, man, they're blown away on how intelligent I have made them sound, because again, a patent language is a different language, and the way we're putting things together and drafting a patent application, you're going to sound extremely sophisticated as you're an inventor. If you're an inventor reading this patent, like, man, so that's what Joe Rogan is saying. What? This is crazy, man. This is all you right here. But again, he has to give shout outs to the patent attorney at that point, because I've been in that situation where somebody's reading a patent application like, man, I sound a lot smart doing this. And not saying that Terrance Howard is not smart and he doesn't know his stuff, but just in terms of the way we write as patent attorneys, we make this document sound very sophisticated, sound very like, okay, this person has a intellectual awareness about themselves. So let me kind of go to the screen here so we can go through this patent. So he said he has a worldwide patent. That's not true. So again, to his credit, it does say his name, inventor, Terrance Howard, Deshaun Howard. So it does list him as an individual inventor, which is a cool thing. Man, everything that he wrote in the abstract. And again, this was filed in 2010. So let's back up a little bit. First and foremost, do you guys think that augmented reality, virtual reality had just come into form in 2010, or do you think that this thing was way before then? I know the Pokemon game, what was that, like 2008? This was big when I was in like college or something. Maybe that was after 2008. But again, newsflash, AR VR has been around for a long time. He didn't create the AR VR universe first and foremost. So let me clear that up right now. And again, essentially everything that Joe Rogan read in the abstract is Again, it sounds fancy because that's the patent attorney job to make this document sound fancy. And that's just kind of the way we write as the patent attorney. But all that stuff is definitely nothing new. So I guess going down here, he doesn't have a worldwide patent. There's no such thing as a worldwide patent, which I tell people all the time. There's no one-stop shop where you're going to get a patent that covers everything in the world. First of all, he said two things wrong there. Number one, he said he has a worldwide patent, but then number two, he said the patent was abandoned. He never had a patent on this. As you see here, the status is, let me go to, as you see here on the right-hand side, the status was abandoned. Blow this up a little bit. There you go. You see that the status was abandoned, and it was filed again April 22nd in 2010. And it was given obviously a serial number, but it was never issued into a patent. If it was issued into a patent, it would have the patent number. It would say granted, and it would have the U.S. patent number on here. But again, this is just a U.S. What we're looking at here is a U.S. publication. This is not a worldwide patent. He didn't even file a PCT application. And again, I'm gonna give him some credit because again, this stuff can get very convoluted and complex, especially when you're not in the world and don't understand the lingo. So I'm gonna just say, okay, maybe he was kind of speaking out of turn. So. But again, I don't want you guys to be confused. Like, man, Terrance going around talking about Terrance Howard had this worldwide patent that they got over on him on. Number one, he didn't have any patent. It was filed in April 22nd, 2010, and it was abandoned. Again, it was abandoned 6 months later, which goes to show you, this is the crazy thing is, when you file a patent application, typically it doesn't even get picked up until a year and a half, 2 years later. Interestingly enough, his case was abandoned 6 months later. Now, I'm not going to say that it wasn't any. That's very interesting. Typically, it'll go through prosecution. It'll have some type of office action that's issued. Which again, that office action is issued 2 years later in a lot of cases. Definitely not 6 months later, unless it's he filed for expedited prosecution. But again, the fact that it was abandoned 6 months after filing, that's very interesting because you don't see that too often. But let's go back up to the patent before we get back to the interview here. So again, no such thing as a worldwide patent. You have to file a patent in each country that you want to go in. You can't file what is called a PCT application, which is kind of give you rights in the PCT stands for Paris Cooperation Treaty, and all the member countries of that PCT Paris Cooperation Treaty. I guess you get, what's the best way to explain it? You essentially get filing rights in those countries. But again, you still have to go file individually in those countries that you want patent protection in. It's just not like, okay, you filed a PCT application to get worldwide protection in all these countries. No, you have to go file an application at some point in time. We call it nationalizing it. You have to go file a patent application. If you want it in China, you have to go in China. If you want a patent rights in Canada, you have to go to Canada. If you want patent rights in Germany, you have to file in Germany. In China, you have to file in China. Each country that's a member to the PCT, you have to file individually in that country. There's no such thing as you're going to file a PCT application that's going to issue it to a worldwide patent. So just trying to clear up some of these crazy things that Terrance Howard was saying. Again, like I said, I'm going to tell him, I'm going to give him that he just don't know the lingo, and I ain't going to hold him his feet to the fire for that. But again, his patent application is the proper term, his patent application, because he did file a patent application, which is the U.S. publication, this 2010 number, which again, the 2010 just means that it was filed in 2010, and it never issued into a patent. So he never had a patent on the actual invention. And again, from reading that abstract, that was nothing new, even though it sounds fancy when Joe Rogan was reading it. Let's try to get back to the video because hey, I was sent this one, man, and when somebody sent this to me and said patents, I had to review it, but he said he was talking crazy on this one, so let's get back to it.
Tap on there. It's right under where it says abandoned. Yep,
cited by 31.
Cited by 31. It's to the right. Yep, right there. Tap on there and look at all the companies. If you look at the patent, these companies have all earned. They have multi-billion-dollar companies they built off of my patent. Just roll through.
Sony, Microsoft, Amazon,
Hewlett Packard.
Yeah.
Keep going. IBM, and it's still making money. This patent has earned over $7 trillion. And
you didn't get it.
And I haven't gotten a penny of it. When they did all of the
man, and I think Joe Rogan at this point, he knows that he's blowing smoke on his behind. Again, let's go to it again. What he's talking about. And I'm explaining it to you as a patent attorney. Again, I deal with this stuff every day, so I know exactly what he's saying. What he's saying is not true. Number one, like I said, he does have a patent, definitely not a worldwide patent. Yeah, his patent was abandoned, so he's talking about that. This is just a detailed description, but at the end of it, or at the bottom of the patent here, you have this cited by. So if you look at this thing, let's see, publication date. So you see these dates. So typically, when other people come after you and file a patent application. Again, when the examiner picks up the actual application to examine it, he's going to find, or she's going to find, everything that was filed before your patent application that's dealing with your invention, and they're going to cite it against your application. So, for example, Terrance Howard, he filed his application in 2010. So say I come along and file a patent application on a similar technology in 2012. For example, this publication, the priority date was 2007. That's crazy that its priority date was before. But say in 2011. So then the examiner is going to pick that up, say 2 years later from the priority, or from the non-provisional date, the date it was filed from a non-provisional standpoint, and he's going to find everything that is in a realm of that he can cite against my application that was filed before I filed my application. And that's essentially what he's doing here. So Terrance Howard, what he's saying is, hey, each of these publications, and some of these publications may not have been. So, for example, these were issued into a patent, 9,342,467. These 3 are actually issued patents from Sony, Hewlett Packard, Amazon Technologies. But these ones, I'm not sure if they actually issued into an actual patent, but these are publications. They may have issued to a patent, they may not, but they cited his case. That's not mean that they're taking his invention. No, the examiner, this has nothing to do, and that's the crazy thing about this is this has nothing to do with the actual company. So he's making it sound like Hewlett Packard or Sony took my patent. This has nothing to do with Hewlett, and that's a separate conversation, but they may have looked at it. But this has nothing to do with the actual company that filed for a patent application after he filed for his. This is the examiner at the USPTO. They pick up Sony's application that was filed after Terrance Howard filed his. They're going to read the invention. They're going to say, okay, yeah, they're going to find everything that was filed before. And again, in this case, Sony, if they filed their patent application, the examiner picks it up. They're going to find everything that was filed before Sony filed their application. Again, it may have been Terrance Howard application, obviously, as shown here. They're going to cite that in an office action against Sony, against Amazon, against Hewlett Packard. That doesn't mean that these companies were taking Terrance Howard's invention or his ideas. That has nothing to do with that. That just pretty much means that the examiner at the United States Patent and Trademark Office thought the invention was similar enough to the point where he wanted to cite. Matter of fact, the examiner tried to stop Sony, tried to stop Amazon from getting a patent on theirs by citing Terrance Howard's patent. Now, typically, if you have a good attorney, they're going to file what is called a response to that office action from the USPTO and say why theirs are different from Terrance Howard's application. And it seems like at least a few of them, or a nice amount of them. Let me go back to the screen here. It seems at least that a nice amount of them were able to succeed. So we're going to go to cited by. So everything that has, if you have a 2010 or a 2012, that means, at least in this case, this is still is a publication. But to the extent that you see a number 9 in front, those are issued patents. So that's telling me that these companies, Amazon, Hewlett Packard, Frederick Thomas, Sony Corporation, they were able to get over or convince the patent office that their invention was different enough from Terrance Howard's patent application to the extent that they were due a patent on their application. Again, Hewlett Packard again down here. Hewlett Packard's they got busy in this space. You had a European patent from ATTI, an international service company. So again, man, hopefully you guys are picking up what I'm putting down. He's trying to make it seem like these companies were biting off his ideas, and we're going to finish up the video, but he's trying to make it seem like these companies, these big companies, and again, obviously the AR/VR space is a huge space that makes a ton of money, but he's trying to make it seem like these big companies were biting or took his ideal and all of a sudden made all this money. No, what they did was they invented what we call over your ideal, where they provide an invention that was different enough, or that hopefully different enough in a better way over what you did not get a patent on in your patent application, and they were able to get a patent issued patent on. This doesn't mean that they were somehow just copying your stuff and made a ton of money. That's not what that means, and I think he's mischaracterizing it. I definitely wanted to clear that up, because look at, man, that's what I do, man. You say patents. Somebody sent this to me and said patents. Let's get back to the video. But when somebody sent this to me and said patents, they said he was talking crazy, and I had to review this, guys, with you. So we're gonna finish up here. Let's go.
Black Lives Matter, like Raytheon Company, and IBM. If you
Crazy.
and it still has another 9 years, another 8 years in which I would be making money off it. But what they didn't know is they didn't understand is how it was really supposed to work. So they've just been taking this gun and been using it as a bat. And if they wanted to know, I could.
Man, where is Stephen A. Smith where you need him? Stay off the weed. You don't have a patent. For everybody out there, a patent is good for 20 years. And to the extent that you have an issued patent and you pay your maintenance fees, it can extend as long as 20 years. But you don't have a patent. So he's talking about, hey, it's good for another 8 or 9 years. And as if they were infringing his patent. Dude, you don't have a patent. So they're not infringing something that you don't have. And again, I can't even say he's trying to embellish or he just doesn't know. He clearly knows that he doesn't have a patent. Now, maybe he think it was some foul play involved. Now I'll give him that because I don't know about that. But to go around saying he has a worldwide patent, he patented everything in the AR/VR universe. These other companies are infringing or took his idea. It's just simply not true. And any patent attorney will tell you this. So let's get back to the video as we finish up here. Let's see what other crazy stuff he talk about. I love you, Terrance, but you're out of pocket on this one.
Show them how it really, really works. But this is proof that my stuff is legit.
So let me ask you this before we stray away from this too much. The concept of gravity. So if it's all electricity that's causing these forces and it's all outside in, when the Saturn V rocket.
Gravity, man. I don't want to hear that. Again, hopefully you guys got some value out of this one because he definitely was talking crazy out of it. Just to give you some highlights, there's no such thing as a worldwide patent. Number 2, he filed a patent application on this AR/VR concept that was not issued. It was abandoned, which was crazy that it was abandoned, 6 months later. It typically doesn't happen like that. But his patent, Terrance Howard's patent application was abandoned and never issued into a patent. Number 3, the USPTO, the examiner at the USPTO cited Terrance Howard's patent against Sony and Amazon and Hewlett Packard to try to stop these companies from getting a patent, issued patent on their patent application. And they were able to, at least a lot of them were able to argue successfully that their invention was different from Terrance Howard to the extent that the USPTO awarded them a patent. What was the other one? So this had nothing to do with these companies taking his invention. I guess number 4, he doesn't have any time left on his patent application because it was not issued into a patent. Again, a patent is good for 20 years. And to the extent that it issues into a patent, his publication never issued. So he never had rights to his invention. And 5, shout out to Joe Rogan for the content. And that's it. So hopefully you guys got something out of this video. If you guys come across some of these type videos, send them to me. I can review them, react to them. Again, man, Terrance Howard, I love you. But as my man Stephen A. Smith say, stay off the weed.